In this video, we're going to look at how privilege, both attorney-client privilege and work product privilege, work when your client is a corporation. A little bit different than when you have an individual as a client. Because a corporation is a legal person, the corporation holds the privilege and is the only person, so to speak, that can waive the privilege. So the owner or the holder of attorney-client privilege is, in fact, the corporation. If it is going to be waived, that decision is made generally by the board of directors of the corporation, but the corporation itself is still the legal holder or owner of the privilege. The next question is, what communications are protected under attorney-client privilege? You can't really talk to a corporation, yet they are the legal client. So how do we know what communications are protected? There's basically two tests that are used. The control group test would protect any communications between the management responsible for the corporation in that legal action and the attorneys. The subject matter test, and this is the test that you want to pay attention to because this is the test we follow in Pennsylvania. The subject matter test says that attorney-client privilege attaches to communications between the attorney and any employees who communicate with the attorney regarding the legal matter. So if you're working for a company and there's a legal situation and the attorney comes and talks to you personally about that situation, you aren't the client. Your corporation, your company, your employer is the client, but your communications with the attorney would be protected by the attorney-client privilege. The only one who could waive that privilege would be the corporation. So the communications are protected, but you yourself do not become the client just because those communications are protected. Okay, so that's the first thing you want to keep straight. So let's look at a situation. Okay, so in this exercise, we have Victor, who is an accountant with the A1 Corporation, and he writes a memo to Linda, who's the CEO and president of this company, about some possible accounting irregularities in their previous year's financial statements. After getting the memo, Linda, who again is the CEO and president, she meets with several employees, the chief financial officer, the chief accountant, several other accountants. She takes notes of these interviews, she puts them in a file. A couple years later, in 2017, the corporation hires attorney Susan to defend them against charges that have been filed related to these allegedly illegal accounting practices. So now the attorney's involved in 2017, and the attorney interviews Linda, who is still president and CEO of the company. She interviews Victor, who is no longer employed by the company. She also interviews various other employees that are still employed by the company. All these interviews are conducted in private settings, and Susan kept notes of these meetings. Susan also gets a copy of the memo that Victor sent the CEO and president. So looking at this memo, and again, this memo was from employee to president of the company. Susan, the attorney, now has a copy of this memo. Is the memo protected by attorney-client privilege? No, the memo is not protected. It is not a direct communication between client or anyone protected by the attorney-client privilege and the attorney. It is a pre-existing document that has now been given to the attorney. Had the CEO of the corporation sent an email to the attorney, that you could argue is a direct communication about the case, confidential setting, would be protected. Pre-existing document does not fall under that direct communication, so it is not protected by attorney-client privilege. Is the memo protected by the work product rule? No, it is not. And this is the one that tends to be more confusing. If you just keep in mind what the work product rule is intended to do, which is let us develop our cases without having to disclose what we are doing within reason to the other side. It protects our mental impressions, and this memo is not a mental impression, it's a pre-existing document. It also protects information we go out and collect from people other than our client. Our client cannot give us pre-existing documents and as a way to hide evidence in a case. So the work product rule does not hide evidence, This is the only way the other side can get this information. So if they were to send us a request for production of documents asking for such a memo, we would have to disclose it to the other side. Is the memo protected by the ethical rules of confidentiality? Absolutely. If you are ever in doubt and you're asked if something is protected by confidentiality, say yes, because confidentiality protects everything we know about our client's case, regardless of the source, regardless of who else has the information, regardless of how we learned about it. So it is protected by confidentiality. Okay, the next section, the notes of the interviews that Linda took with her employees. And again, Linda is the CEO and president of the corporation. She took this information, wrote it down, and now she's given it to the attorney. Okay, tell you right now, the answers are identical to the answers regarding the memo. Are they protected by attorney-client privilege? No. This is not a direct communication. This is a pre-existing document that the CEO has now turned over to the attorney. It is not protected by attorney-client privilege. Are these notes protected by work product rule? Again, no. These are not notes that the attorney or the paralegal has taken of their conversations with employees. These are notes that the president and CEO took. So it is not part of the development of the case. And again, it could be potential evidence. So it is not protected by work product rule. Are they protected by the ethical rules of confidentiality? They absolutely are. Okay, so the next section, regarding Susan's interview with Linda. So Susan's the attorney. She's now hired. She's speaking with the CEO and president of the company. Is her interview, the conversation she's having with the CEO, protected by attorney-client privilege? Yes, they are. Again, you look at the three-pronged test for attorney-client privilege: direct communication between attorney and client. And you have that because it's a conversation they're having. It's about the case at hand, and we can assume it is a confidential setting because that's how we always talk to clients, in a confidential setting. Because Linda is an employee of the corporate client and she's talking to the attorney about the case, these communications will be protected by attorney-client privilege. The corporation is still the client. Linda is not the client, but the communication she has with the attorney are protected by attorney-client privilege. Notes that the attorney takes of her conversation with Linda protected by the work product rule? Yes. This is her notes of her conversation with someone who is a representative of her client. This will always be protected. This is our internal mental impressions, our ideas, our thoughts regarding talking with this person. So at this point, they are protected by work product rule and they would not be discoverable. Is the conversation, the notes of the conversation, protected by ethical rules of confidentiality? Of course they are. Its answer is always yes. Okay. Next one, Susan now interviews Victor. Okay, now Victor was an employee of the company. He is no longer an employee of the company. Is the discussion he has with the attorney protected by attorney-client privilege? No. And the reason it's not is because he is no longer an employee of the company. Under the subject matter test, the attorney-client privilege will protect communications between the attorney and current employees of the company, not former employees. So these communications do not get the benefit of protection under the attorney-client privilege. However, they are protected by the work product rule. When we go out and talk to witnesses and we take notes of those conversations with the witness, our notes are protected by the work product rule. So even though the attorney-client privilege would not apply to our communications with Victor, any notes we take regarding those communications, those would be protected by the work product rule. And is our communication with Victor protected by confidentiality? Absolutely. Susan, the attorney, also interviews other A1 employees, some of the same employees that the CEO had interviewed earlier. Are they protected by attorney-client privilege? Yes, those communications are protected. These answers are going to be identical to the ones in Section C. Susan interviewed Linda, who's the CEO. Now Susan's interviewing other A1 employees. Under the subject matter test, Those communications are protected by attorney-client privilege because they're current employees. Are they protected by the work product rule? Are the notes of those conversations protected by work product rule? Yes, they are. You're talking to potential witnesses, you're taking notes, that's part of your development of the case. They're protected by the work product rule and are not discoverable by the other side. Are the notes or the conversations protected by the ethical rules of confidentiality? They absolutely are protected by confidentiality. Okay, so this is a really important concept for you to understand and understand how to apply these concepts to a corporate client scenario like this one. So make sure that you do understand it and make sure that if you have any questions, you do ask for clarification because I can guarantee you that you will see something similar like this on the test.